constitutional amendments without recall, the legality and realism of parliamentary authority in Somalia's constitutional development. This article examines the constitutional and legal legitimacy of amending Somalia's provisional constitution without reconvening the 825-member Constituent Assembly that ratified it in 2012. Drawing from constitutional jurisprudence, legal positivism, political and legal realism, and comparative constitutional practice, it argues that the federal parliament of Somalia possesses full authority under Article 135 to carry out constitutional amendments. The passage and presidential assent of 4 amended chapters of the Constitution by Parliament is therefore lawful, legitimate, and binding, in full conformity with Somalia's constitutional framework and international norms of post-conflict constitutionalism. In August 2012, the Somali Provisional Constitution was adopted by a National Constituent Assembly composed of 825 members representing the full breadth of Somali clans. This assembly was convened for a specific transitional function and disbanded upon the adoption of the Constitution. The continuing authority for constitutional amendments now lies with the Federal Parliament of Somalia, which has lawfully exercised this power by passing 4 key chapters recently signed into law by the President. This article demonstrates that the procedure used was constitutionally valid and aligned with jurisprudential theory and comparative international norms. The constitutional framework and Article 135. Article 135 of the Somali Provisional Constitution vests the federal parliament with the authority to complete and amend the Constitution during the transitional period. Parliament also derives legislative powers from Articles 79, 132, and 134. These provisions collectively affirm that the Constitution was designed to be amended and finalized by the legislative body, not the original assembly, whose role was confined to adoption. Accordingly, enacting the 4 constitutional chapters through Parliament and having the President sign them represents a valid constitutional process. Jurisprudential foundations, positivism, constitutionalism, and sovereignty. Hans Kelson's pure theory of law provides a doctrinal basis for understanding the hierarchy of legal norms. A constitutional amendment is valid if enacted through the procedures defined by the Constitution, the grundnorm of the legal system in Somalia. Amendments passed under Article 135 by Parliament are legally binding. HLA Hart similarly emphasizes the rule of recognition, under which rules gain validity through accepted institutional procedures. As John Locke articulated, the principle of constitutionalism entails the people delegating authority to institutions that act on their behalf. Once sovereignty is transferred to Parliament through the Constitution, it does not revert to transitional bodies. Moreover, Rousseau's concept of popular sovereignty reinforces that legitimacy resides with ongoing representative institutions, not temporary assemblies. Realism, legal and political realist theory. Legal realism, developed by scholars such as Oliver Wendell Holmes Jr. and Jerome Frank, holds that law must be understood as abstract rules and principles enforced by functioning institutions. From this perspective, the Constituent Assembly, having no legal or institutional presence, cannot override a constitutionally grounded legislative process. Political realism further argues that legitimacy arises from the practical exercise of sovereign authority in fragile and post-conflict states like Somalia, where the continuity and functionality of institutions are paramount. The federal parliament, as the sole sovereign and representative body, is the only realistic and legitimate actor capable of managing constitutional amendments. International comparative practice. Somalia's approach is well aligned with international constitutional norms. Constitutional amendments in South Africa, India, Brazil, and Germany are carried out exclusively by legislative institutions without re-engaging original constituent assemblies. Over 120 countries globally follow this approach. Somalia's recent passage of 4 constitutional chapters via parliament and executive assent is not exceptional. It is standard democratic constitutional practice. Sovereignty, functionality, and the legality of the 4 chapters. The 4 amended chapters have been lawfully passed by the Somali Federal Parliament and signed into law by the President, by Article 135. This represents the correct constitutional process, fulfilling procedural and substantive legal requirements. To require the reassembly of the 2012 Constituent Assembly would be an extraordinary and unfounded departure from established principles of constitutional order, democratic representation, and sovereign continuity. Conclusion. The Federal Parliament of Somalia has acted entirely within its constitutional authority in amending the 4 chapters of the Provisional Constitution. The process followed is consistent with Somalia's constitutional provisions, jurisprudential principles of legal positivism and constitutionalism. The realist view that law must function through legitimate, sovereign institutions. International constitutional practice. Therefore, the 4 amended chapters are legally valid, binding, and enforceable. Because the Constituent Assembly was not recalled, there is no legal, political, or jurisprudential basis to challenge its legitimacy. Somalia's constitutional development is proceeding within the law and in line with international standards for post-conflict constitutional reform. This paper was prepared by Abdullahi M. Hassan, Abdullah Yabaro, legal researcher, co-founder and director of the Federal Dialogue, the National Unity Program, and the Legal Office at Malak Forum, a Somali-based research organization. He holds a Master of Laws, LLM, and is a legal researcher, political scholar, and international legal advisor. His expertise includes public international law, human rights law, and federal dialogue processes, focusing on legal reform, governance, and state building in post-conflict and transitional contexts. Abdullahi remains dedicated to advancing inclusive governance, legal development, and the rule of law through research, advocacy, and strategic legal counsel at national and international levels. Until next time, stay curious.